is working, and then I'll stop sharing and hand it over to you.
Perfect.
All right. Hi, everyone. If you're watching, we are about to start. All right. And we are presenting today. I am on Facebook Live, so that's great. It's working. We're doing Making Decisions Together, Understanding Guardianship and Supported Decision Making. And today, Caleb Alford from the ARC is going to present. He's the Associate Executive Director of Impact. And Caleb does a lot of great work, as do all the ARCs around Texas. So we're glad to have you. And I'm going to stop sharing and I'm going to turn it over to Caleb to present on this topic.
Awesome. Yes, thank you for having me. I'm excited to be here today. As Jackie said, I'm Caleb Alford. I'm the Associate Executive Director of Impact with the ARC of the Capital Area. Just a little bit about me while I'm loading this up. I've been with the ARC for about 8 years now. I started here as an intern in the Human Development Family Sciences Department at UT Austin. My passion is serving people with disabilities. I've been working with people with disabilities for about 15 years or so now. I started at Easter Seals camps in Alberta and British Columbia over the summers while I was at UT. I got to work in Canada with adults with disabilities. That it was my first exposure working with this population. Canadians really just do services right. We took our adult clients whitewater rafting, high ropes coursing. We took them to a bar. We did all kinds of really cool and awesome things with them. And it really helped me see how much we truly don't help these individuals do what they want to do, right? Like in Texas, sometimes I feel like they're babied a lot. And so my mission coming back to Texas was like, you know what, we need our services to be better. So I came back to UT, switched my major, found the ARC, and I've been here ever since. And now I oversee all the programs I started in as an intern. So that also includes our guardianship program. So I'm super excited to be here today. I did change the title of our slide just a little bit to be more broad. It's more over all of the alternatives of guardianship and then guardianship itself. Again, like I said, I do oversee our guardianship program here at the ARC of the Capital Area here in Austin. We offer one of two low-cost options across the state of Texas for guardianship, only charging $200. We are hoping to expand this program to Williamson County next, and I believe there's some similar program in Galveston County. So that's just a little bit about me. A quick history about the ARC of the Capital Area. We were founded in 1949 by a group of parents who wanted the same opportunities for their loved ones as non-disabled children. It's been in Austin for almost 77 years. Which is a really long time. We're one of the longest continuously running nonprofits here, pre-existing prior to local authorities in the counties around Texas as well. So we've been here a long time helping support people with disabilities and navigating services. So the first question I like to ask for people when we're looking at guardianship and alternatives is, does my loved one need legal guardianship or can we function with an alternative to guardianship instead? And the answer to that is it depends on each individual's life, the environment they're in, the people in their daily life, their ability to maneuver the community, ability to convey needs and wants, medical necessities, and behavioral supports. So really the options you would just need, either an alternative or guardianship itself, would depend on your loved one and their life and their needs. And we'll break that down a little more as we move forward. All right, I'm getting some water. So how I'll break this down first is we'll go over all the alternatives to guardianship. In the state of Texas and in the disability realm, we always try to do the least restrictive option first, whether it be within special education or in guardianship. Always we're pushing for the least restrictive option. In case of guardianship, the least restrictive option would be an alternative guardianship. The reason why it's considered a least restrictive option is meaning that you aren't taking away your loved one's rights. These documents are literally just here to support them. It does not give you the right to make full decisions for them. It just helps you enable and support them through making the right decisions. That's why it's listed as an alternative guardianship, and they are listed as the least restrictive option over guardianship. Some options for alternatives to guardianship include power of attorneys, supported decision-making agreements, representative payee, designated representative, authorized representative, and disability trusts. One little thing I want to add to this is, although these are alternatives to guardianship and are some of the most common ones, you can have some of these while having guardianship as well. And it's because of just the certain areas they touch. So I'll get more into that as we go forward. So the first ones we're going to talk about are powers of attorney as an alternative to guardianship. And there are two main types. And a POA is a document that allows a person or the principal to decide in advance whom they trust and want to act on their behalf should they become incapacitated of making decisions for themselves. The person who acts on behalf of the principal is called the agent. I may call them the support, and the principal I'll usually call the person with a disability, just for clarity purposes. So I just want to state that again is the biggest thing is this allows the person with a disability to choose someone who they trust to help make decisions for them when they become unable to do so for themselves. And a lot of people don't realize for alternatives to guardianship specific to medical power of attorney that power of attorney only allows you to make medical decisions for your loved one once they're incapacitated. You can make no medical decisions for them until they're incapacitated, meaning they're in a coma, knocked out, their mental health is so severe they can't make competent decisions. That is when you can make medical decisions for them and only then. So having medical power of attorney is only an option when that incident happens, and it's to prevent exploitation and abuse. Financial power of attorney is a little different. If you have, there's different types of financial powers of attorney. One of them can be active when they're not incapacitated, and one can activate only when they become incapacitated. So there's some options you have when it comes to the financial side. And a financial POA gives an agent the ability to make financial decisions on behalf of the person with a disability. It is common to appoint one person to act as an agent for both financial and healthcare decisions, but in some cases, it may be wise to separate these two out. So these are the two different types of powers of attorney. One more simple way I explain this to people, when you're thinking of alternatives to guardianship, if your loved one with a disability cannot understand the basic principle that a medical power of attorney will allow mom or dad or the person supporting them to help make medical decisions when they're knocked out or incapacitated, if they can't just understand that basic thing that document, the power of attorney will enable their parent to help them, then that may not be the option for them. The reason for that is all these alternatives to guardianship, in order for them to be legal binding, your loved one has to understand from a basic standard what they mean. If your loved one cannot understand what they mean from a basic level, then more than likely this is not the right answer for them. The reason for that is the person has to have capacity in order to write and sign their name on these documents to be legal binding. If they can't do that, then guardianship is probably the answer, because guardianship is for those who are considered incapacitated in the eyes of the law, meaning they are at risk of not knowing what they are signing or agreeing to, which could put them at risk of exploitation or abuse. But I hope that makes sense. That's a simple way to explain it. If your loved one can't understand the basics of these power alternatives to guardianship, guardianship will probably be the answer for them. So I just like to simplify that for people while we go through this. So now I'm going to break down each power of attorney a little bit and what they can and can't do. So what can a medical POA do? The POA grants the powers of the support to be narrow depending on how the document is written or filled out. There are a few examples below that they can do. They can decide what medical care the person receives, including hospital care, surgery, psychiatric, home health care. And this depends on the financial needs of the person with a disability. They can decide which doctors the person sees, where they live, who gets to decide within their housing, their decisions regarding that, whether it be a group home and stuff, what the principal eats, and who bathes the principal. And again, this is only once the person with a disability is incapacitated can the medical power of attorney then make these decisions. One more thing I don't think I cover on these powers of attorneys is these power of attorneys can be invalidated at any point if the person rips it up or says they no longer want you to be their POA. That can make it invalid, and then you don't have powers going forward. A lot of people don't realize that, and they do try to use these as guardianship, but these are not guardianship. Guardianship is a full legal process that goes to court and is a full legal proceeding. These are just notaries or signing with a witness to make them legal binding. So what can a financial POA do? They can access the principal's financial accounts to pay for healthcare, housing needs, or other bills. They can file taxes on behalf of the person with a disability, make investment decisions for them, collect their debts, manage their property, and apply for public benefits such as Medicaid or veterans benefits for the person with a disability. So that's the two things that medical powers of attorneys can do and financial powers of attorneys can do. And this is a list of things they cannot do. A generic POA document that does not contain limitations in the document that's being signed or written on gives the support broad power over medical or financial decisions. However, there are still a few things that they cannot do for the person with a disability. And one of the fundamental rules of governing the person with a disability is that they have to act in the best interest or with fiduciary responsibility for the person with a disability. The support cannot change the person with a disability's will. They can't break their fiduciary responsibility. They have to act in the best interest of the person. They cannot make decisions on behalf of the person with a disability after their death. They can't transfer POA to someone else. And they have the right to decline their own appointment, but they can't just choose who they want it to switch over to. It has to be the person with a disability who makes that decision. So these are a few things they cannot do. Another real quick thing on this too is these POAs can prevent you from putting your loved one into like a state supported living center too. Even guardianship will not allow you to just put your loved one into a state supported living center. The court would have to approve that. It's because the state supported living center is one of the most restrictive living options out there. So just a heads up on that too. So now we're going to talk about specific PO types of POAs. I've already talked about financial and medical power of attorneys broadly and what you can and can't do with them. Now these are specific types of those. These I believe are specific to financial though. I've not really seen these options for medical. I've only seen them for financial. And them being general POA, which just is generally what the document is, right? Like as it's written, you sign it and get it notarized. Limited POA, you specify in the document what limited powers you want the support to have within that document. A durable POA, which I recommend to families a lot. This one is the only one for financial that is active when they're both not incapacitated and when they're incapacitated. And this is only for financial. It doesn't allow you to do it for medical. So you could do a durable financial power of attorney document that is both active when they're not incapacitated and incapacitated. So it does both sides. That one gives you the power to do it on both ends. Spring POA only takes effect once a certain event happens that's written into the paperwork. And then again, medical POA, like I said, that one is just only works for medical reasons once your loved one is incapacitated and you can make medical decisions on their behalf. One thing with medical POA is you could lose that. Like, say your loved one is incapacitated due to mental health reasons. Say they have autism and they're just having a really tough time and just can't. They're having a behavioral challenge and they just can't get through it. And you're then able to make medical decisions. But say in a week or two, they actually have capacity again. Your medical power of attorney then technically wouldn't be able to be used because they have the ability to make decisions on their own again. So that was all about powers of attorneys. Like I said, medical, financial, what they can and can't do, the different types of them as well. And just so you know, too, for these alternatives, medical and financial, you can actually go online. I go to Google, type in Texas MPOA, Texas Medical Power of Attorney, and you can find the document on there. You can download it in English or Spanish. It just needs a notary with your loved one present to sign. And again, they have to understand what they're signing with the notary. And the notary, you can get it from your bank, HEB. There's all kinds of places to get it notarized. And as soon as it's notarized and good, it's legal binding at that point. But again, your loved one can rip it up or and void it at any point in time too, as a power to help prevent exploitation and abuse. So the next one we're going to talk about is supported decision-making agreement. And this is one that a lot of people have heard of more recently. This became law in 2015, and Texas was actually one of the first states to do it, which go us, we're usually one of the last. So good job for something, Texas. Where there was only 9 states that were using it, but more and more are now using it. It requires only 2 witnesses to sign it, no notary required. And it's just a document you can print from the Arc of Texas's website, and it just allows you to help support your loved one in decisions. It does not make you the decision maker. Just as the document reads, supported decision making. You are helping your loved one make a decision. You are not making the decision for them or on their behalf. This document, I like to warn people, when it came out, we thought it was going to be a little more powerful. It's actually not as powerful as people were hoping for because there is no one mandating it. There's no office looking to make sure people are following the rules with it. So an agency can decline to allow it, and you don't really have any pushback on it. The best place I have seen it being utilized has been utilized in ARD meetings for loved ones who are over the age of 18, who are in 18 plus programming. A parent who does not have guardianship of their loved one over 18 can use supported decision-making agreement to request all their ARD paperwork ahead of time to review with the person with the disability. So then that person can make decisions on their own in the ARD meeting. You can also be present in the ARD meeting too to help them talk through things. So that's the biggest thing with decision-making. You don't get to make it for them. You just get to help them talk through it and make it and request all the documentation ahead of time with them to review. And again, it allows the individual to make their own decisions and stay in charge of their lives while receiving any support they need to do so. All people need support, and so this allows people to and able to do so legally. And it's just a really great thing that helps prevent having to do the full medical power of attorney or notary and things like that as well. But again, it is very limited in its powers. So that was supported decision making. So that's the second type of alternative. The next one we're going to talk about is representative payee. The first few that I've already talked about, those are options only available to those who use alternatives. If you get legal guardianship, you cannot have a medical power of attorney, a financial power of attorney, or supported decision-making agreement, because for those 3 ones I already talked about to be valid, your loved one cannot have the capacity. It has to have capacity to understand what they're signing. When you're going for guardianship, you're arguing to the court that your loved one does not have capacity. So if you're arguing to the court, my loved one does not have capacity, this is why I need guardianship, but yet you have a medical power of attorney, financial, and supported decision-making agreement, you're contradicting yourself. And the court might ask why. The one thing I have seen is people obviously will sometimes do these alternatives to get them to guardianship while they're waiting, right? You would just want it to end before your court date or before you even go for filing. That's not best practice. That's just something, one of those things people just, services are hard when you don't have these support. So I have seen people make them no longer, the powers of attorney is no longer existing before the court date. So then that way, when they go to the front of the judge, they don't have active medicals of power of attorney actively working. So that has been one loophole I've seen people try to do for that. Though you can't have those first three with that guardianship, you can be the guardian and the representative payee. And a representative payee is a person or agency or organization or institution we select to manage the benefits to determine what the individual is able to do so for themselves. So if your loved one can't manage their SSI benefits, you can become the rep payee through the Social Security Administration, or an agency can if you prefer. And that would help you maintain and manage all your loved one's SSI benefits. And you can do this while you're guardian as well. You must be 18 years or older. The person being supported has to be legally incompetent. I have seen some people who do have capacity still have a rep pay because they struggle with financial literacy and stuff. And so their parents have been rep paid through Social Security Administration still. And it's for anyone that Social Security Administration determines incapable of managing or directing of their own benefits. And you must go through the SSI website to apply to be the rep payee. It's just a form online, and it's an easy thing to fill out, and it allows you to help your child. You will get a letter in the mail, and your loved one will get a letter too. It will say for your child to you, and that knows your rep. That shows you that you're representative payee. It's great. It allows you to call the Social Security Administration without your loved one being present too, and make decisions. And it makes it a lot easier when working with them, especially if your loved one is nonverbal. They will require you to get signatures from your loved one and able to become rep payee, but unless you're already guardian, then you don't need those signatures. So that's the fourth one we've talked about so far. We've done medical power of attorney, financial power of attorney, supported decision-making agreement, and rep payee. Next, we have designated representative. This one can get a little confusing for some families, especially if you're not familiar with Medicaid waivers or how some of our attendant hours are paid through consumer-directed services or CFC dollars. Consumer-directed services is a consumer-directed option for some of the waivers, meaning you, the consumer, can hire and fire your own staff that you work with for your waiver for attendant care or different day stuff. A lot of times it's hard for an individual to do this on their own. A person with a disability hiring and firing their staff can be very difficult in dealing with payroll. And so one way to navigate that would be getting someone listed as your designated representative to help you do all this. So a parent can become the DR for their child to make this decision. If you are a legal guardian with guardianship, you can already do so. But if you have a supported decision or an alternative to guardianship, this would help you be able to support your loved one in the waiver capacity regarding the hiring and firing their staff. Again, that's just a hard role and task to do, right? So this option enables you to be able to support them. And I believe you would get it filled out through the Medicaid office, I believe, or the provider for those Medicaid waiver services can help navigate you to find that document. Super helpful though. Let's see, and that one I've not seen as much, but it's something that can be used. Another one that is utilized that I've actually heard of more recently too over the last few years is authorized representative, or AR, an applicant, person receiving benefits, or someone with legal authority to act on their behalf, such as legal guardian or power of attorney, may designate a person or organization as an authorized representative. This is a great thing, especially when it comes to like benefits, like Medicaid benefits and stuff. The last one I talked about, designated representative, only lets you help them hire and fire their staff and payroll stuff related to the waiver attendant care hours. Authorized representative allows you to talk to Medicaid without them, apply for Medicaid without them, deny appeal or stop an appeal with Medicaid without them, do an interview without them. This allows you to act for them through Medicaid. So your loved one would have to sign when you're filling out the Medicaid application that they would like you to be listed as an authorized representative. If your loved one doesn't live in your home, your loved one will get all the Medicaid paperwork mailed to their house, but you will also get a letter mailed to you too as a copy to help them. If you have appeal processes you need to do and your loved one can't do it, you're able to do it for them without them being on the phone. If you don't have authorized representative or guardianship of a person with a disability, the person with a disability will have to be on the phone with you every time you call Medicaid. But with this, you will not need them present. Again, it allows you to sign an application on behalf of the applicant, complete and submit renewal forms for Medicaid, receive copies of notice or renewal forms in the language you prefer, designate a health plan, act on behalf of them. And it's really just a great way to really help out with everything related to Medicaid. Because if you don't and you call 211, your loved one will literally have to spell out your full name and without you saying a word before they'll talk to you. This will allow you to do so without having to go through all that. Again, this is just to help out the individual, and it's not meant to be used for like exploitation purposes or anything like that. So it's just to help them navigate these services. So we've talked about a few of those other options. The next one that we're going to talk about, and I believe this is the last one, would be trusts. And there's a few options for trusts. And you can have guardianship and still have a trust as well. And so I'll go through that too. So trusts enable parents, for example, to leave money for children who are Medicaid eligible. This third-party trust or parent for child can provide a source for the purchase of amenities without affecting your child's ongoing eligibility for their SSI or Medicaid benefits. Medicaid does not consider the trust as a countable asset, and properly structured distributions from the trust are not countable income either. So again, like if your loved one's getting benefits and you expect them to get inheritance or something, it doesn't even have to be a big inheritance. You can utilize different types of trusts in order to protect their benefits, but also allow them to have that money. And it gets deeper into the woods, and I won't go to it too much today, but it can vary in like what's counted as earned and what's not considered an asset and things like that. Some of those options include a special needs trust with private attorneys. That is a more expensive option, but usually people who maybe have a higher inheritance will hire someone to get it more specialized. There's also the master pooled trust with the Arc of Texas that serves the whole state of Texas. So our Texas chapter of the Arc here in Austin area, people mix them up with us. We're the local Austin chapter, but the Arc of Texas is physically here in Austin too. They do the master pooled trust, and that is a cheaper option for families. It pulls everyone together, and the Arc of Texas manages it, and there's a fee on top of that for them to manage it. But it does make it more affordable since it's multiple families all together under that trust. The last option that I don't think is on here is ABLE accounts. That is another lower option for like money to help maintain benefits. That one is nice because it only costs like $50 to start, I believe, and has a debit card associated with it, and it plays nicely with a special needs trust. A lot of people don't realize special needs trust can only be utilized for certain things, including, I think it can be used for rent, but you can't use it for utilities. Whereas an ABLE account can be used for anything quality of life related to the person with a disability. So your special needs trust can feed funds to the ABLE account, and you can use the ABLE account to go on a trip or pay for groceries or pay for the light bill. So that's the loophole, is funneling the funds into the ABLE account to cover anything quality of life for the person with a disability. Again, I try not to go too deep into it. I love all these different topics, so I could definitely go talk all day about each one of them. So that was all the alternatives to guardianship that are out there that we primarily see or work with in our area. These are just great things to know about. And again, if your loved one can't understand what most of these are meaning on just a basic level, more than likely guardianship will be the answer for them. I also ask families, if your loved one's at risk of signing up for a loan, if someone said, go take this loan out for me, and they're at risk for that and not knowing they shouldn't do so, that could also be a case to argue that they may need guardianship as well, because that potential for exploitation or abuse. On our screen here, this is not just for Travis County, I do not believe, but it's at least in the Central Texas area, possibly. The University of Texas School for Law has an Alternatives to Guardianship project and workshop that's free to families. They will actually, the students who are going forward with law school but aren't quite a lawyer yet, will work with a teacher to hear your case and talk to you and your family, and they'll decide if they feel, based off their opinion, if your loved one needs guardianship or not. If they don't need guardianship, they'll actually do the powers of attorney with you in person that day. If they feel you do need guardianship, they'll go ahead and let you know that alternatives will not work for you. And so it's just kind of nice that that's something they can offer to families too. But again, I'm not sure if it's just Travis County or not, but feel free to scan this QR code and look at it. I know that they're at least at UT, and they may be open to other places too. So I know I talked a lot already about alternatives to guardianship. The next thing we're going to get into is the legal process of guardianship itself. And again, the alternatives had to be for those who have capacity or can understand on a basic level kind of what they're understanding and signing, whereas guardianship is for those who are at risk because they may not understand that stuff. And so they need a guardian to prevent potential exploitation or abuse. So like I said before too, guardianship is the most restrictive option when it comes to this, because you are taking away a lot of rights of your loved one. So what is guardianship and why consider it? Guardianship is a legal process where the court determines if a person is incapacitated, meaning they are significantly unable to care for themselves. This includes being unable to manage their finances, provide their basic needs such as food, clothing, and shelter, or maintain their physical health due to a disability or mental condition. That is one thing I want to share with families too, is guardianship and powers of attorney and alternatives to guardianship are not just for people with disabilities. They're actually for elderly people sometimes too, and those with mental health conditions as well. So a lot of times in my field, I'm like, all right, this is not just for disabilities. It's actually for all kinds of different people. But I sometimes just see it in that disability lens. But I have to remind myself it's not just for people with disabilities. It's for people who are elderly and mental health struggles as well. And you may hear me say incapacitated or incompetent a lot. That is not a term I typically will use. It's just it's a law term that is used in the guardianship proceedings. So you just may hear me use that because it's a term they use in the court system. Why consider guardianship? It provides necessary support and protection for individuals who are unable to make decisions independently, and it helps ensure the decisions about health, finances, and basic needs are made in the best interest of the individual. So there are actually types of guardianship. A lot of people don't know there's two types of guardianship. Those being guardianship of the person. where the guardian has authority over the wards, and you'll see this term too, sorry. Ward means person with a disability or the person going for guardianship over themselves. I'm going to say the person with a disability for our presentation purposes. It just says ward in here because that's the word used in the court setting. So the guardian has authority over the person with a disability to provide personal care, including medical care, living arrangements, daily activities, and etc. And then there's guardianship of the estate. The guardian has authority over the person with disabilities, financial matters, managing assets, paying bills, making financial decisions, etc. So one thing with these two types of guardianship is that when you go for guardianship of your loved one, if they have an estate you do think they're going to inherit and someone's going for guardianship, they would actually have to file two guardianship filings. One is for guardianship of the person and the other is for guardianship of their estate. So these are not the same court proceeding, they're separate court hearing dates and meetings. One is for the person themselves and the other is over their estate. You do not have to do both. The families that work with us in our program here at the ARC, we only do guardianship of the person. We don't touch the estate due to potential legal battle issues and things like that. But we do guardianship of the person only. So you do not have to do guardian of the estate if your loved one is not going to have an estate. You can just do guardianship of the person. And that is the typical guardianship. When everyone thinks of guardianship, they're typically thinking of guardianship of the person. So with these guardianship types, both person and estate, there's actually some other types within it. There's full guardianship and limited guardianship. So what full guardianship is that the guardian has complete authority over one or both types of guardians, both the guardianship of the person and guardianship of the estate. So actually that's the clarifying part. When you have full guardianship, you're guardian of both the person and of the estate. You have decisions over both. This makes you can make all decisions related to their healthcare, living arrangements, and their finances. If you have guardianship of the estate too, then you could still become rep pay if they have benefits, but it's not as common if they have that big of an estate too. And then there's limited guardianship. This guardian authority is limited by the court to either guardianship of the person, guardianship of the estate, or both. And the court may allow the ward to retain some decision-making powers in areas where they still are capable, while the guardian handles the other areas where the person with disability needs assistance. So I use limited in this way with limited guardian of the person. We had a family a few years ago. She didn't want her son to lose his right to get to vote or have a driver's license. So she got limited guardianship of the person, and that allowed him to keep his right to vote and his right to get a driver's license. Because a lot of families don't realize when you go for guardianship, you're removing their right to get married, their right to sign, their right to have a driver's license, their right to more things too. It takes away a lot of their rights. So if you are worried about some of those rights and would like for your loved one to keep them, you can do limited guardianship of the person, enabling them to keep some of those rights. Just know that if you try to go back a few years later to take away those rights, it's going to be very difficult. The court will ask why. So they just want to know it's easier to take it away later or to give it back later than to take it away again later. So I always just let people know that as a heads up when going for the court proceedings. So here's some examples of both full guardianship and limited. So full guardianship of the person, the guardian has complete authority over the person's care, healthcare, living arrangements, and daily care, but they do not have authority over the ward's financial matters. And actually, I wanted to clarify one more thing. There is another term used for having both full and limited, or full of a person and estate, but I don't know if I put it in this slideshow, and I'll have to find it. But there's a term that's sometimes used for both I've seen. But again, full for the person is you have all the authority over all their personal care stuff, but you don't have anything over their estate. Full guardianship of the state, you have complete authority over their finances, but you have no authority over their personal decisions, care decisions. This is the term, sorry, plenary guardianship, both full guardianship of the person and full guardianship of the estate. This guardian has authority over both the ward's personal care and financial matters. So if you have both full guardianship of the person and full guardianship of the estate, you have plenary guardianship of them. So that's an example of those different full types. Limited guardianship examples include limited guardianship of the person. The guardian may make some personal care decisions for the ward, but allow the ward to retain control over their personal decisions, like right to vote, apply for a driver's license, or make their own social choices. Limited guardianship of the estate, the guardian may handle certain financial matters, like paying bills or managing assets, but they may allow the ward to make their own financial decisions on their own, like spending money, managing their daily expenses, or handling investments. So these are some good examples of limited of each of those types too. So the next thing I'm going to talk about for these types is how to obtain them. So for someone to obtain guardianship, they must have an attorney submit the application and represent them in the final hearing. This is a full court proceeding. It's almost like it's not like a law. I'm trying to think. It's almost like you're serving someone in a way, like you're going for a full-on court battle with your loved one who will have attorneys. You'll have attorneys arguing why you need guardianship over them, and their attorneys will also try to argue the other, unless they do truly see that that person with disability needs guardianship over them. It goes in front of typically the probate court in the county that you proceed in or live in. And it's actually the probate court of the county your loved one lives in. So if your loved one you're trying to get guardianship over lives in Travis County, but you live in Harris County, you would do your court paperwork for guardianship in Travis County. You do not have to live in Travis County. It's where your loved one lives. Just I always like to stress that for families. It's where your loved one lives. You're trying to get guardianship over. That is the county you do your guardianship in. You can transfer to other counties. You cannot. You can transfer to other states. It's a little more difficult though, but it's easier to transfer within counties. It costs anywhere from $3,000 to $5,000 privately paid, depending on the attorney you go with. It's because typically they charge anywhere from $300 to $400 an hour for these paperwork type stuffs and just in your meetings. So this is why it can become so expensive. When it becomes contentious, like say a biological parent or a sibling refuses to sign a certain document the court requires called a waiver to allow their mom or dad to go for guardianship with their brother or sister. If those siblings or that bio dad refuses to sign that, that becomes a contentious guardianship and it becomes a legal battle that gets super expensive or can lead to being super expensive. I've heard guardianship getting as expensive as 10,000 plus. It's usually for guardianship with the state though too. So it can get very expensive. There are options in some counties called court-initiated guardianship. I like to stress that too. Not a lot of people know about it. Travis County has it. Wilco has it. They all have their different options regarding it. But it is a way to possibly get a lower cost where the court will file on your behalf and they may waive filing fees too. So I like to recommend that to people too, is look at your probate court. Usually it's in the family section and ask about court-initiated guardianship filing if needed, if you can't afford a private pay attorney in your area, or you're not in the Travis County area for our program here for the Arc of the Capital area. The next thing, so that's the total cost just for the submission of it all with the court, right? Having attorney fees, is there is a bond payment, and these bond payments vary per county as well. If you're in Travis County, they have a $100 annual bond or a one-time fee of $375, never pay it again. If you're in Wilco, I heard the judge there is if you're a bio parent, then you can get a lifetime bond and never pay again. It kind of just depends on the judge and the county you're in, what that bond payment looks like. Some do not have a lifetime bond that you can pay off and never pay again. I'm very happy that Travis County offers this one-time $375 fee, because then families I've met who've been paying $100 every year for 20 plus years can pay this fee and never pay again. So I wish more counties in Texas offer this option for bonds. And the bond cost does vary per county as well. So again, you must have guardianship in the county the person with a disability resides in the state of Texas, and you, the legal guardian, can live anywhere you'd like. You don't even have to live in the state of Texas. You can live out of state too. And it is the cost that affects guardianship is contested guardianship and or uncontested guardianship. Contested is where you have issues with other family not wanting you to go for guardian. And uncontested is where everything is smooth, easy to go. Everyone signs the required documentation and you're good to go. That is uncontested guardianship and usually a lot cheaper. So I already went through this a little bit. I think this was just a slide I meant to take out. Yes, I meant to take this one out. That's just a repeat. So what illegal guardianship cannot do is you are not allowed to move the protected person out of state without letting the court know. You cannot put them in a long-term secured residential long-term care facility like the state supported living center. It's an exploitation preventative from the courts. Is you cannot, just because your guardian, you're not allowed to put your loved one just in the SLLC just because. You have to get court permission to do so. It's just to prevent exploitation. You can't spend or invest their money the way you would like to. It's for their best interest. And you have to ask the court for approval for monthly budget if they have guardianship of the estate. You cannot sell their home or any real estate property if they have guardianship of the estate and you're the guardian for that. And you can't make any changes to their last will or testament either. Those are things you can't do. One more thing that I've seen on here that we don't have listed on here, but I've heard in the past is guardianship will also not allow you to, some parents in the past have wanted to use it for sterilization of their loved one. You cannot use guardianship to sterilize a person with a disability. That is not something that is allowed anymore. And I only say that because we have heard people wanting to use it for that reason. It will not allow you to do so. That is something we do not do anymore in this realm. And so just as a heads up, guardianship will not allow you to just do any medical procedure on your loved one either. There is some rules you have to follow with having guardianship. So termination of guardianship. Terminating guardianship is usually when you're only released if the person with the disability has passed away, they've regained their capacity fully. So say, again, this is more that mental health side. I used the Britney Spears conservatorship example. She regained capacity and the court was able to remove her conservatorship or her guardianship from her. Or the guardianship is over a child who has turned 18, because technically you're guardian of your loved one until they turn 18. And then once they hit 18, you lose your guardianship over them. You're then petitioning to the court to then extend your guardianship past the age of 18 due to whatever reason, due to the disability, mental health, or age. So that's kind of the way I like to explain that. Let's see what else we have on here. So this is just a slide from my programs. The ARCS guardianship program, we do have about a 2-year wait list because we're one of 2 in the whole state for at a low cost. I am happy to talk with people more who have questions related to guardianship if they just would like a one-off meeting with me. We are hoping to expand this program into Williamson County in the next few years and eventually Hayes County as well. So we're working on that. Guardianship is a very complex situation. One thing I do like to share with families too that I don't think I have on here is that when you are going for guardianship, the main things you have to prepare for is that obviously the cost. You will have to prove that your loved one is incapacitated or disabled enough to need a guardian. And to do so, you will either use your local authority's determination of intellectual disability, or a DID, to prove that, as long as it's within the last 2 years completed. And or you'll get a doctor form by the court to fill that out by a doctor stating your loved one has a disability severe enough for guardianship. Those two, one of those 2 documents will be enough proof to prove disability to move forward. And then the other hurdle that people have, and other than proving disability in the right form the court needs, is getting everyone related biologically to the person with the disability, whether it be their dad, half siblings in another state or another country, anyone biologically related that is a sibling or parent has to sign what's called a waiver to go for guardianship. What it's saying is they're waiving their right to file for guardianship right now. They're letting you go for it now instead. And so even if they're a half sibling who's never met your loved one, they can live in, we've had a family who the kid had half siblings in Mexico he's never met. They still had to sign the waiver because we knew where they were at. If you know where they're at and they tell you no, they won't sign that waiver, then your guardianship can get contested or may not be able to go forward with it. So I always warn families with that is one hurdle a lot of people hit, is not getting the waiver signed because the siblings won't do it or the dad is no longer in the picture and won't. The only caveat with that is if you can prove to the court you tried your best to locate them and you couldn't find them, then you're fine. You don't have to get them to sign it. You just have to do your due diligence to prove you couldn't find them for the court to let you move forward without those waivers. If you do find them and the court knows you found them and they tell you no, that is when you are going to have some trouble going forward with guardianship. And that's when it can get contested and expensive because you may have to serve them. There's a whole legal thing going on in the back end for that. So I just like to warn people with those. Getting the disability determination from the local authority, especially if it's not within the last 2 years, and or getting the doctor to sign a document. And the last thing is the waivers for guardianship. And thank you. I think that's all I have. If anyone has any questions or anything at all, I'm happy to talk more about it. But that is our presentation.
Hey, Caleb, thank you so much. That was like so much great information.
Yeah.
We've got like just 2 or 3 questions, but they are things that come up quite a bit. So for our autistic young adults, teens, etc. So one of them is about just scams and manipulation, because we find that like I mean, almost everyone with autism seems extremely susceptible to scams and manipulation.
Yes.
Even some of our college graduates, and so you mentioned it's almost better to get guardianship if you feel like that they may be a target for that. Um, is that, but then again, they were probably capable of making decisions
Right.
and other things. Is there what would be the other backup if you didn't want to do something as restrictive as guardianship? Is it financial power of attorney or anything? Is there anything else that you could protect them without
Yeah. I
doing
would I
guardianship?
think financial probably would. You could try to do like partial guardianship with the person. Like I have had a mom come in who let her son keep certain rights so that she could just protect him related to finances only. And he actually was the reason we were able to move forward with it is he verbally was okay with it. Like he said to the judge, I am okay with my mom being guardian. I need her help. So that allowed the judge to move forward. And especially our judge in Travis County has been here 45 years. It's Judge Guy Herman. He's chill. He really relies on the person explaining it to. Like if your loved one is okay with it, that would be fine. if your loved one is going to say, I don't want it, and you know they need it, I would say probably financial power of attorney, statutory durable financial power of attorney would be the best because it's when they're not incapacitated when they are. And that way, if they get a loan out, you're like, no, I'm their financial. Like I'm the one who has to get the loan out for you. You can't make them do it. You know what I mean? That would
Yeah.
probably be the best way to prevent that. Doesn't mean they can't still sign stuff, but related to finances, it could help prevent that.
Okay, that's great. Good info.
And call 911 and report them for to the adult protective services too.
Okay, that's good
Yeah.
to know. All right, good tip. And then the other thing that was like, I didn't realize and is a little disappointing to hear, but the supported decision-making agreements are not really like
Yeah.
holding a lot of weight or clout. So, and then so if you do have someone that is probably better, just needs some like support in just life and making,
Mm-hmm.
gathering information, what would you suggest for those like young adults
Yeah.
or as they're aging up into 18?
I would definitely get the medical and financial power of attorneys if they'll allow you to do so, especially the medical. Sometimes we've seen it's helpful for those who maybe may struggle with some mental health struggles later in life and may hit a moment where they're not incapacitated due to the mental health struggle and then are non-compliant, right, for things. That might help so that you have the medical so then it can take effect. So I would still suggest getting the medical and financial for that. Having supported decision-making agreement too, just because why not? It's easy to do. And even though it may not have a lot of clout, some places do accept it fine, but some places don't. So it's worth having because the worst thing they'll tell you is no, right? Just to have an option of support. Um, I'm trying to think what else you could do. I would definitely do the authorized representative with Medicaid and the rep pay with SSI as well. Because
Okay.
that way you can still call without them being on the phone. Like say they're in 18 plus programming, they're in school and you don't want to call Medicaid with them and take them out of school, right? You could call on their behalf and help deal with all that without them. That has been I found that an agency could do it and we're a nonprofit. So I was able to do it for a client who was his own guardian and asked for me. It helped me get stuff done because he was constantly working and it was always his decision on what was we're going forward with, but still at least I could help him without him always being on the call too for 3 hours. So
Okay, great. All right, thanks. And then we have another question.
mhm,
If you care for your child and they are under 18, at
mhm.
what point should you begin the guardian process and get an attorney?
Good question. So you can go into your guardianship hearing on the day as the earliest you can do is the day they turn 18. So the day they turn 18, you can be in front of the judge. That is the earliest you can do a guardianship filing. So you can have up to 6 months prior to the hearing to file it because it can take some time for paperwork. Just know you can't physically be in front of the judge until the day your loved one is 18, because that would be the day they then are their own guardian. So then in theory, that's when you could do it. Doesn't mean it always falls like that, right? But in theory, it would be that date.
Okay, that's
But
really
you can do it
helpful.
anytime past 18. They can be 40 and you can go for guardianship now. You don't have to wait. You don't have to do it at 18. You can do it anytime after 18.
Okay, great. Are there like a lot of repercussions to waiting?
No, I mean, other than you might run the risk of your loved one not being compliant for certain Medicaid things or like healthcare stuff, right? Or needing a HCS crisis diversion and they refuse to sign it, even though that's something they really need, right? And they could get the waiver right away, but they refuse to sign it because of mental health reasons or whatever. So it might be better to get it early so you have all the ducks in a row.
Okay,
So,
that makes sense. Okay, I think that is all of our questions. One thing that I was curious about, I know I'm pretty familiar because I do state advocacy. I know a lot about, I know the ARC of Texas, and I know there's lots of ARCs around the state. I know here in the Austin area, you guys, obviously you're here and you're super knowledgeable. Do the other ARCs around the state offer similar services in these areas? Do
it
you know?
varies. They all vary. So we are, even though we're all like the ARCs, we're all different in a way. So we all run our different services. Like here at the ARC of Capital, we have 4-day program locations: class case management, non-waiver case management, guardianship, adult programming, and special education advocacy and employment services with Dell as well. Whereas the ARC of Fort Bend, I think, has like a day program and like a maybe advocacy program, right? So they each have their own little things. The ARC in San Antonio has mostly day programs and class case management. So they all vary.
Okay,
We're the
got
only one that I know of in this area with guardianship. And we've run our guardianship program almost 20 years now.
amazing. Okay. Well, you
Yeah.
guys are a wealth of knowledge. So
Yeah.
thank you. Okay, great. Well,
Yeah.
I don't think we have any other questions, but if anyone's watching, you can definitely reach out to us and
Yes.
we can connect you with
There's
Caleb.
my contact info on the screen too. And all those referral links are to our programs at the ARC as well.
Amazing. Okay, yes. And we know they're really great programs as well. So we appreciate everything that the
Of
ARC does.
course. If anyone has any questions, feel free to reach out to me. I always say email or text me to get a meeting, and I'm happy to have a one-off call with you. I won't charge you 300 an hour for questions since I'm not an attorney, but I'll help you out.
That's great. All right. Well, thanks. We're going to go ahead and end this now. And we appreciate everybody watching. Thanks.